Good morning, everyone. Thank you for joining us today. My name is Helen Brannock. I'm the Research Facilitation Manager at HTQ. I'd like to thank everybody for attending. This is our session 3 on intellectual property. And I'd like to thank Ranak Prasad from Matter Research, who will be talking to us today about the HTQ Research Passport Agreement project schedule exemplar that he has developed with a working group from across the partnership. So before I hand over to Ranak, I'd like to acknowledge the traditional owners and their custodians of the lands on which we meet. I pay my respects to their ancestors and their descendants who continue cultural and spiritual connections to country, and I recognise their valuable contributions to Australia, to Australian and global society. Ranak, I'd like to hand over to you. We will be doing questions and answers during the session. Ranak will keep an eye on those, and then we can catch up on any that we haven't answered at the end. Thanks.
Thank you, Helen. Thank you, everyone, for attending today, and thank you for allowing me to speak today. My name is Ranak Prasad. I'm the Senior Research Agreements Officer for Matter Research. And as Helen mentioned, as part of a working group, ran the working group to develop an exemplar to essentially assist both researchers and reviewers to completing the HTQ Research Passport Agreement schedule. I'll just call it the schedule just for ease throughout the presentation. But I did want to start here by saying thank you to the contributors whose names you'll see on the screen at the moment. And some of those names you'll recognize, and they come with a wide range of experience, and they were extremely insightful. And over a number of sessions that we had, they helped to develop the schedule exemplar that you will see today, and that will be available for you. And the idea was essentially to increase the suite of tools that are available for everyone, and also ensuring that we create consistent schedules. There's a lot of information that can be floating around. You've got your funding submission, you've got your ethics application, you've got your protocol, you've got your governance application. So we want to really create a consistent schedule that everyone sort of speaks the same language, if you will. And we recognize that there's a lot of those documentation that exists already. And so we really want to minimize the time that's spent on these documents, and also mitigating the duplication of effort. So what we'll do is we'll go through parts of the schedule. I'm not going to go through each and every section, primarily just the key sections, to talk about what guidance we provided, and also talk about, from a developer perspective, also providing some advice about what we're looking for, both as a reviewer, but as a drafter. And so some of the information I'll provide is stuff that we, or myself, provide to staff in learning how to actually draft these contracts. So we'll go through, and as Helen mentioned, if you do have any questions, feel free to just pop them into the chat and I'll answer them. To start with, I had some takeaways that I wanted to sort of put in, and I sort of made them a little bit quirky, so hopefully you'll remember them after you go away from the session. So the first one is remember the 5-year rule. So the 5-year rule is what we talk about, where a lot of staff can move in and out from these projects, and whether it be from the research office side or from the actual agreements, from the actual study team. And so what we try and remember is that if you look at this document in 5 years' time, is it going to make sense to a third party? And so the document, the schedule, should be readable and understandable from a third party perspective. The second one, a schedule should have legs. What I mean by that is the schedule on its own should be able to stand up. So like I said before, there's a protocol usually associated with the project. There's usually an ethics and a governance application. And we can refer to those documents if needed, but ideally the schedule should contain enough information that if you read it, you get a brief understanding of the project without having to refer to secondary documents. The third one is draft per party. We're going to get into this later into the session. But what this means is when you're drafting the schedule, it's best to do it on a per party basis. And this ensures that it's nice and clear who's responsible for what, and it mitigates the amount of changes you have to make if, say, a member of the research team leaves or gets replaced. So you'll see this, and I'll point it out as we get through it. And the last one is to keep it succinct. As I mentioned, and as we've said, the protocol does exist. So we can always refer to the protocol if there's more technical information that we need, but for the purposes of the schedule, it's best to keep it succinct and minimize sort of very complex walls of text, if you will. So now we're going to get into the actual exemplar. So it's not available publicly yet, but it will be made available through the assets directory, if I'm not mistaken. Check in the chat. So the shaded text that you'll see down here is the guidance information that you'll be provided. And so we've created a dummy project, which will be in the darker text, but the shaded text is for guidance. So talking about the project description, so generally we don't need the full protocol listed in here. We just need a brief overview of what the project aims to do. And generally, let's say something like the lay summary plus a combination of the aims of the project is more than enough. And again, referring to the protocol, we can read the more in-depth description if we need. So the next section is talking about the partners. So you'll see there's a list of parties listed here. So these are the current partners to the umbrella agreement, which sits above the schedule. So only these parties are actually permitted at the moment to use this Schedule 2 agreement. So just tick all the boxes that apply for all the parties that are participating in the project. Now, talking about the head agreement, so most often it's going to be a funding agreement that will be linked to the project, in which case you would just provide yes. If not, it would be NA. Having a head agreement does sometimes mean that your commencement date and your completion date will be tied in or aligned with the funding agreement. But by and large, what we often find is that usually having your contract commence upon the execution of the agreement is the most suitable commencement date. But if you do need to, for example, a funding agreement, as we said, you can actually specify an actual date. Similarly, for the completion date, we typically link it to the HTQ approval expiry, because we know that that document typically runs in line with the project and it can be extended from time to time. So it gives us the flexibility that the agreement can run as long as it needs to, as long as the project remains open. Again, if you do need to specify an actual date, you do have the option to do so. So I've just sort of moved down to the section here. The ethics approval and the SSA reference number should be relatively straightforward to most of the study team. So these are just the numbers that reference numbers you get from the relevant ethics committee or the governance office. So you do include the numbers or the reference ID in there, so that if we do need to, as reviewers, we can go and actually locate or request further information from the relevant officers and get further information if we need. Touching briefly on this bottom section here, where we're talking about the coordinating principal investigator, or CPI as we call it, you don't actually need to list all the specific details of the investigator. You just need to list who the CPI is. And then the next section is where you'll list all the details. So you'll start to see that third tip that I gave before, which is talking about drafting per party. So you'll see here we've got Metro South HHS. So we've listed all the Metro South investigators. Again, these are all fictitious names and details, so it's not, and none of these people are real. So we've listed on a per party basis, and it keeps it nice and clear. So you should always be including the best contact details, because we may need to get in touch with investigators, and that could be from a reviewer perspective. So ideally an email and a phone number is best. And also list the most appropriate affiliation. We recognize that there are individuals who hold multiple either academic or clinical titles. Please select the one that's most appropriate for the project that is being conducted. Now, there may be situations where a researcher may be wearing two hats in a project, and so there may be what we call as a conflict of interest, in which case we would recommend that you talk to the research office of your institution, if you are a researcher, that is, to discuss how that needs to be addressed. Just looking at a question, just bear with me for a moment. So the question was, if the agreement end date is related to the expiry of the HTQ approval, if that project ends, that has been contracted via the HTQ schedule, but the HTQ approval is kept alive by extensions, do you expect the lead party to then formally terminate that agreement? Yes. So if there is a reason to terminate the agreement, but the HTQ is remaining open for whatever reason, then yes, there would be an expectation that you talk to the relevant personnel at the research office to terminate that agreement. We don't often find, in my experience at least, that it's been the case that we needed to terminate an agreement much sooner than the HTRAC, but there could certainly be a reason that may happen. I'm not saying it's not possible. So in that case, yes, would need to take the relevant steps to terminate that agreement. And generally that will be through your research office. So providing them details of the agreement, providing them details of the project, and then we can work to notify all the relevant parties about terminating the agreement. And generally that's not a difficult process. That's something that can be managed pretty easily. Hopefully that answers your question, but if there's more on that, I'm happy to clarify. So speaking about, sorry, I'll just go back a step. In the investigator section, you wouldn't actually list students. So students do have their own separate section in the schedule. So it's actually not a lot of information that you require in the schedule itself. That's not to say you won't get questions outside of that. But for the purposes of the schedule, what you really need to do is list the name of the student, the type of project they're doing. So whether they're a PhD or a master's or what have you, their enrolling institution and their best contact details. We may, and students can come on and off the project. We recognize that that's the case. And in that case, we may need to do deeds of variation to the schedule so we can add or remove students to the project, but we can also do variations for various different changes that need to happen to an agreement for the life of the project. And I do have a bit at the end about sort of big variations. And in terms of the student supervisor, again, you just need to list the name of the supervisor in this section. By and large, the supervisor usually would be an investigator listed in the previous section on the schedule, but that's not to say you can't list an external individual who needs to be listed as supervisor. That's perfectly fine as well. Moving on to this section, I won't touch on it too much because it's mostly for the research officers. It's talking about the address of service for parties. So basically this means that if there's any issues, let's say from a legal or administrative perspective, then who do you contact? Technical notices, which is, let's say, issues about the research itself, can typically be addressed to the CPI. So you would just include the details of, so you can see this is the CPI that was listed a few sections back, but any administrative or legal notices need to go to the relevant research office. So that would be an executive level office or similar. But if you're not comfortable, you don't know the details of your research office or the other research office, if you're a researcher completing this, then feel free to leave this blank and it can be completed by the research office at the time. So don't worry about that section too much if you're having trouble with it, because it can be quite complicated and difficult to get all the information. But I think we had discussed possibly making this information available. I'm not sure if we've got to it just yet, but it may be available in the resources directory in the future. So this is where we really want to focus in on the schedules and where some of the tips I had mentioned at the start of the seminar will become useful. So I'm looking at the activities first of all. So activities to be conducted by the parties really talks about the actual activities that each of the parties will be doing in the project. So thinking about your protocol, we don't necessarily need a copy paste of the protocol. What we really want to do, I'm just going to come back to that supervisor question in just a moment. I'll do this section first. So the activities to be conducted by the parties talks about what each party will actually do. And so we want to keep it very brief. We want to keep it succinct, and we want to group it by parties. So you can see we've got UQ listed as doing ethics and governance submissions, data analysis, publication, and dissemination of findings. So that's a very brief overview of what needs to be done. It doesn't dive very in-depth about each and every step of the process because the protocol does exist for that purpose. And then we've also got Metro South, who's also doing this. Feel free to duplicate it if you need. So you can see that publication is covered both under UQ and Metro South because both of those parties are conducting those activities. So ensure that each of your parties that are listed on the project should ideally be showing up in this section, because at least you should be identifying what their role is in the project in this section. So keep it restricted to parties only. You don't really, ideally, you shouldn't have to name individual investigators who are conducting specific activities, because as I said, these individuals can move around a lot. So you want to mitigate the amount of changes you want to do. So keep it brief and feel free to duplicate it as you need. I'm just going to hop back to the question here about supervisors. The question was, if I could clarify about student supervisors, can you name a supervisor who is not otherwise an investigator on the project? Yes, you can name a supervisor who is not otherwise an investigator on the project. But for the most part, usually the investigators are involved in the project, but you can have people who are not on the project as supervisors. That is fine. So hopping down to the funding section. So when we're talking about funding, we should only be talking about funding that is relevant to the project itself, and that will be transferred between the parties. So you do have a few options here. So you've got option one, no funding will be transferred between the parties. So that's, I think, relatively self-explanatory. Option two, so we've got UQ in this example. So UQ has received funding from the Exemplar Foundation under the head agreement and is the administering institution of this funding. And that UQ will pay Metro South, which is one of the parties in here, $50,000 in total. And then the funding is transferred upon execution of this agreement and spent in accordance with the budget. So a few things there when we're talking about option two. So you want to be clear who's administering the funds. You want to be clear on which portion of the funding is being transferred to which party and for what purpose. And you'll also want to include details about how the parties will receive payment, or they might request payment. So in this one, we've got upon execution of this agreement, but in other situations, it may be subject to an invoice. And you should also include a budget where needed. So you can, and in this situation, we've got it as an appendix to the agreement. There should ideally be a budget which the parties can refer to if they need to understand the terms under which they need to spend or should be spending. So again, just a reminder, please include only funding that's relevant to the project. I understand there may be sort of various pots of funding relevant to the project overall, but try and keep it limited to what's relevant for the project. So I won't talk about the address of finance. That's relatively straightforward. It's talking about the section before. So it's about who the finance office is at each relevant party that receives the funding. I do want to talk about the contributions section because this is often an area where people can get tripped up. And this is not exclusive to researchers, beyond the reviewer and the office side as well. So contributions talks about in-kind or cash contributions by parties that aren't being transferred between parties. So when I'm talking about cash contributions, it could also mean stuff like equipment or access to facilities, but by and large, we're talking about staff time contribution to conduct the activities. So you'll see that the activities is capitalized here, and that's referring to the activity section we spoke about just before. So this is why the activity section becomes really important, because when you get down to sections like contributions, is being clear that these activities that the party is conducting is being contributed as an in-kind contribution by the staff. If there is anything else in there that you feel like needs to be covered, then it can be listed here, but by and large, most of the time you're talking about in-kind staff time contribution. This section down the bottom here, collecting party, this is talking about, and this will become clear in the next section, talking about who is collecting the study participant data in the project, or if relevant, human biological material. So we don't need the details of how that collection is being done. We just need to know which parties are undertaking either the data or the sample collection. So that's all that section that talks about. And as the guidance information says, if neither of those things are being collected and the project doesn't cover that, just click NA, that's fine as well. So hopping down to the human biological material and study participant data section. So I think it's relatively clear the differences between the two. So we don't necessarily need specific details about each and every type of data point that you're trying to collect, or each and every type of sample that you're trying to collect. But if you keep it brief enough to say, let's say blood or urine samples, or patient demographic data, or survey data, or focus group data, then that's enough information for us to list into the and review from and referring to the protocol if we need to. Sorry, I'm just looking at the question here. So the question was, should we be including FTE portions for in-kind contributions in the section? If you do have the FTE amounts available, then yes, you can answer it. I know certain officers in the governance process will ask you for an FTE portion. So that can be reflected in the agreement as well. So yes, if you do have it available, please do list it. So hopping back to the biological material and the study participant data section. So as I said, provide a brief outline of what is being collected. And so you also need to talk about where this will be transferred. So be clear about the method of transfer and who the data or the material will be transferred to, and when the transfer will occur. So sometimes this may be electronically, it may be throughout the life of the project, or it may be collated at the end and then transferred to a party at the end. So be clear about how that will be occurring. If it's related to data, you do want to be clear about whether the data is identifiable or not, or if the data is being collected in identifiable fashion, whether if it's being transferred to a third party, whether it's being de-identified at the point of transfer. So you'll see a lot of focus on this section, and I know certainly from a reviewer perspective, we would look very closely at this section to understand the type of data that is being exchanged between the parties, and if there's a reason for doing so, if it needs to be identifiable, for example. I will make a note here about student projects, because there can be a lot of investigator student projects where one of the investigators may be using it for their student project and their academic institution may be listed on the agreement. So just as a general note, this may vary from project to project, but typically if you are using the project for a student project, you do need to facilitate a transfer under this section for the research project data to your academic institution as part of your HDR or student project. So it needs to be facilitated by this section. So there's some information listed at the bottom here, which will help you do that, but you would ideally facilitate a transfer from your academic or the other institutions to your enrolling institution for that purpose. But if you have any questions, I understand this may be a sort of hot topic. Feel free to ask any questions. So moving on to the next section. So material transfer is pretty much similar to okay, so one of the questions, sorry, just before I get started, was do we accept as per protocol for these sections? And the answer is no, we don't accept as per protocol. We would require information about, we would require specifics at least, even if it's not, like I said, down to the finer details, but we'll at least require a broad overview of what is being transferred between the parties. And then if we do need to look at really technical information, we can refer to the protocol, but as per protocol, I would not be suitable. Talking about material transfer section is not too dissimilar from study participant and biological sample transfer. It just talks about materials that aren't covered by the above two. So it could be equipment that might be exchanged between the parties for the purposes. So it could be some sort of testing equipment. Be clear again about who's receiving it for what purpose, but also be clear about what needs to happen at the end of the project. Does it need to be returned? Does it need to be destroyed? Or be clear about what that may mean. So talking about, I guess, IP, IP is a big topic, and background IP and project IP are two very distinct things. So some of you may be familiar with it, some of you may not be as familiar with it. So background IP talks about intellectual property that is brought into the project by a party. So it needs to be owned by one of the parties in the project, or at least they have a license to it at least. So when we're talking about IP, we're talking about, let's say, things like a process, a method on a new procedure, a survey tool, or some type of copyright that's being used for the purpose of the project. And so when we're talking in the background IP section, you want to be clear about what the actual IP is, who owns it, and for what purpose it's being used in the project. You don't have to be overly specific in this, but a brief outline is enough. It doesn't mean by way of introducing it into the project as background IP that all the other parties suddenly have ownership over it, because there's an express clause within this contract and many other contracts that background IP remains owned by the party who provides it. So it doesn't mean that you provide parties ownership in perpetuity. It just means you allow the parties in the project to use the IP for the purposes of the project and the project only. So again, just be very clear about what the IP is. If you're unsure, do check with your research office, but you want to be clear about who owns it and for what purpose it's being used. So then when we go down to project IP, this is what we're talking about. Okay, well, if there's any improvements to IP that's introduced, or if there's any new IP that's generated, we want to talk about, well, who owns it. So these three options there. So you can specify a single owner. So let's say if you've got a funding agreement, you may have some restrictions on who may own project IP. So you may need to specify an owner. And in the conversation, it'll come up that, okay, well, there's a specific reason for a specific owner being nominated. You can have common collaborators as tenants in common equal shares. So that means each party in the project will share equally in any project IP. And then this third option says two there, sorry. Collaborators and tenants in common in proportion to inventive or intellectual contributions. So that means that each party will receive a share of the project IP based on the inventive or intellectual contributions they made in generating the IP. So that's a bit of a balanced method, as you can probably understand, to basically assign it based on the contributions each of the party made. So this will vary on an institution basis, depending on what each institution's IP policy may be, or what a funding agreement may dictate. So be open to, there may be some various requirements here, but you would need to sort of consult with your research office on this one. So don't feel like as a researcher, let's say you have to specify one specific thing, and this may be something your office will help you with. I'm just going to refer to one of the questions here. Just be a moment. So the question was, when submitting governance approval applications, there are specific questions about ownership of current and future IP ownership. Where is the best section to include this level of detail? I think, so if I'm understanding your question correctly, it would be where in the schedule we would be nominating that. So that would be this section, but let me know if I misunderstood your question. So I'm going to move on to the next section here. So we're talking specifically these sections here about commercialization, revenue sharing, and other commercialization terms. So again, depending on what the outcome is from the previous sections, there may be certain parties that are nominated to do the commercialization activities, the revenue sharing, and any other commercialization terms. That said, in most of the schedules that we've done, we've typically had a shared IP model. So we typically deal with commercialization, revenue sharing at the time that that activity occurs. So typically we can have a clause to the effect of, this will be determined at the time of commercialization, and similarly for revenue sharing. So because this may not be a relevant issue. So at the time where we're a pre-contract, it may not be something we need to deal with. So we can move this topic further down to when it actually needs to occur, if it needs to occur, that is. So unless there's a specific need to discuss this pre-commencement of the schedule, you can typically leave this as NA or at the time of commercialization. So sort of getting towards the end of the presentation here. So I do want to talk about the special conditions section. So we've included this specific provision in there, but before I do start on that, I do want to talk about the special conditions section, I guess, broadly. So the special conditions section is basically a section where any party can actually introduce clauses that may be relevant for the purposes of the project. So for example, if you've got a funding agreement, you may have some funding terms that need to be flowed down to all the parties, and that all the parties need to sign on to. So that would be a mechanism by which you could do that, as opposed to, because there's no other mechanism in the contract to introduce special conditions. So this is the area where you do this. But there may be other specific requirements for the project that you need to include that may not be dictated by a funding agreement, where you can include special conditions here. So typically your research office again will assist you with the contracting clause, because these are sort of in effect legal clauses. So there may be some specific ways you need to word these clauses to actually have them work the way that you intend. So do talk to your research office, and they can assist you with providing the relevant terms. So now going on to this specific clause. So over the years, we've recognized that projects can go through multiple different iterations, and there may be investigators moving in and out of the project, or there may need to be a lot of changes happening. So we do have a variation, sort of deed of variations. And what happens is we get all the parties to agree that these might be a number of changes that we need to make, and then we accept that from the date of the variation that those changes will take effect. What can often happen though is then we've got multiple different documents where they can be going back multiple different years and you need to refer to multiple documents. So what we've done is drafted a clause to basically allow, if there's lots and lots of variations and you needed to make a big schedule update, what you can do is you can sort of rewrite the schedule as it was originally, but then update sections to acknowledge sections that may have been completed since the original project had started, add in all your new changes, and then include this clause, which basically says that you're going to use the schedule to replace all the previous schedules and variations. So essentially incorporating all the changes into a new schedule. And this clause essentially facilitates that. So there are restrictions as to when you can't use that. So the main restriction is you need to have the same parties into the project. So you can't be using this to replace a party or remove a party or add a party. So as long as your parties essentially remain the same, you can use this clause to do essentially a broad sweeping variation to the agreement. And that way you can essentially you essentially only really have to refer to one document, and it's much easier to keep track of all the changes as opposed to having to refer to previous documents. So there are some requirements. So you'll see that there's a insert date. So you'll want to include the date of the original agreement, but you'll also want to keep copies of the original agreement, any variations, and you'll also want to keep the fully executed copies of those agreements so that you know when they were all signed. If for whatever reason you need to refer those. Your research office will often have a copy of this, but as a researcher, it's good practice, and probably something you want to keep in your site file as well. So as I mentioned, you can incorporate all your changes, mark what activities were done, and then have all the new sort of sections. So that was the main sort of one of the new introductions we wanted to make sort of available to everyone, because we do find that this is a sort of frequent occurrence where we need to sort of incorporate a lot of changes into one. So just some additional tips, just to sort of finish off on, when you do send out your schedule, if it's completed, if you're sending it out to third parties, do provide your protocol ethics approval letter with the documentation. As I sort of mentioned, they kind of go hand in hand, so it's good to also have the protocol to refer to look at, and also understand any more sort of technical details if we need to. Ensure you send it to the right contacts. On the HTQ website, there is a research support directory which contains all the emails and contact details of the relevant officers who you'll need to contact if you need to get a contract reviewed. But this may vary from institution to institution. So some places you may need to submit your contract with your SSA. So be conscious of that. So just bringing back the sort of key takeaways that I mentioned at the start. So remember the 5-year rule. So it should be readable by someone in 5 years' time. The document itself, you should be able to understand without having to refer to additional documents. So you should be able to get a general gist of the project from just the schedule. As I mentioned, draft per party, don't draft per investigator, because that gives you some freedom within how you're drafting and allows you to refer to various different topics as needed. And keep it succinct. Like I said, we've got the protocol if we need to look at it, but the schedule does need to contain some details, so that if we do need very technical information, we can go look at the protocol. That really covers everything. If you do have any other questions, my email is listed on there. We're going to make the exemplar available very soon on the asset directory, or sorry, not the asset directory, on the resources page. So that will be available in the form that you saw, just as a PDF document, but I think we'll make the slides available if we need to. But essentially the exemplar is what you're going to be referring to. But if you do have any questions, feel free to throw them in the chat, or just email me as well.
Thank you so much, Renak, for a fantastic presentation and for all the work that you led with your working group. It really is testament to the knowledge and expertise that we have across the partnership and the generosity of our members in sharing and collaborating. So I'm really thankful on behalf of all of the partners for the work that you've done. As Renak mentioned, we will have all of the information that you saw today up on the HTQ website later on. So you'll be able to download a recording of this presentation. you'll be able to look at the presentation slides and also download the exemplar that Renak shared with you today, as well as, of course, the most up-to-date version of the HTQ Research Passport Agreement. I might just take this opportunity also to let you know, in case you haven't already seen it come through in your inbox, that we had intended just to have these 3 sessions around intellectual property, but we are hosting a 4th session on the 14th of November, and that will be focusing on the legal aspects of Indigenous cultural and intellectual property. We're really excited to host this session. It's a bespoke workshop that's been developed for us by Terry Janke and company, who are a law firm specializing in Indigenous cultural knowledge and intellectual property. So if you haven't already registered, I would encourage you to do so. You can do that via the events page on the HTQ website, or you can follow us on Eventbrite and you can see all of our sessions coming up. And you can also subscribe to our newsletter, and then you won't miss anything at all. Again, I would encourage you, like with all of our sessions, to please share them far and wide. We always welcome attendees from outside the partnership and through all of our networks. So please do forward to your contacts. So again, Renak, thanks so much for your time today. Thanks everybody for attending, and I hope you found it useful.